Welcome to the March 31st, 2026 Zoning Board of Appeals meeting of the Town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to hold roll call. David Murch.
Greg Dean.
Pete Lockwood.
Fred Miller.
Tom Hennessy by Zoom.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at the exhibits presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number 1, call to order. Number 2, approval of minutes from December 30th, 2025 meeting. New business, administrative appeal of an NOV issued on January 15th, 2026 to Joseph Stickney. This will also include discussion of postponement or stay of the appeal application. Number 4 is old business, of which we have none. Number 5, staff communications. And number 6, adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinance or state law. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone, state their name, address, and affiliation with the application, being either for, opposed, or neutral. All persons speaking shall address the chair. Any conversation must be held in abeyance until after the board has formally adjourned. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Appeals from adverse decisions must be filed with the Superior Court or as otherwise provided by law within 45 days of the board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. So next up on our agenda is approval of the minutes for December 30, 2025. Do I have a motion to approve the minutes as written?
I'll give you a motion, David. Motion to approve.
Have a second?
Second.
Do we have any discussion on this? Okay, since Tom is on Zoom, we will do a roll call vote. All those in favor, David Murch, yes.
Greg Dean, yes.
Pete Lockwood, yes.
Fred Miller, yes.
Tom Hennessy, yes.
Very good. Moving on next, new business, administrative appeal of a notice of violation issued January 15th, 2026, filed by Joseph Savitsky, Esquire of Perkins Thomas on behalf of Jonathan Stickney. Property is located at 34 Shore Road, map 78, lot 12 in the LRR1 zone. In addition to this, the board will be discussing postponement and stay of the above application at the appellant's request. I'll take a moment to introduce. The board does have an attorney here tonight that will be assisting the board specifically. This is Attorney Mike Carey. He will be assisting us. In terms of tonight's appeal, we're meeting this evening pursuant to Section 350-7.7 of the Town of Raymond's Shoreland Zoning Ordinance and Section 2691 of Title 30-A of the Maine Revised Statutes. The Zoning Board of Appeals will conduct a hearing on appeal of the notice of violation dated January 15th, 2026 regarding 34 Shore Road in Raymond. This property is owned by Jonathan Stickney. The application was filed in a timely manner as well. Now, before we start, I do have questions for the board. Do any board members know Jonathan Stickney, Brittany McNeil, Aaron Morrill, Brendan Morrill, Douglas Morrill, or Judith Morrill, or have any knowledge of this matter that means you cannot fairly and impartially hear the facts in the record and decide the matter based on the arguments presented at this hearing? I, David Mertz, do not.
I
Any
do not.
question for all of us?
No.
I know Doug because he lives just a few houses down from me, but I didn't know anything about what's going on here, other than once we had a meeting, so I don't know any of the other people.
So no conflict of interest?
Not that I know of, unless
Fred, that
somebody
you-
there, I just know him because he's a neighbor.
Okay.
I don't know him, other than I'm the road manager for the association, and, he comes to our meetings, but I mean, I don't go to his house, or I don't do that kind of stuff. I just don't know him.
So you don't feel anything's going to
I don't.
affect your decision-making
Yeah.
tonight? Okay. Tom?
I know none of the people and have no relationship with any of them.
Okay, very good. Next, I ask Mr. Stickney or his representative to simply introduce themselves, including their name and address and the position. And if you do so, just go ahead and go up to the mic, please. Yeah, please.
Good evening, Mr. Chair. Thanks for the opportunity to be here tonight. I'm Joe Savisky. I'm an attorney at Perkins Thompson.
Okay, and I'm going to stop you right there because that's all I need just for the moment, okay? But you might as well just stay there because
Okay.
I think so I apologize.
I'm here
if I
with Jonathan Stickney, the property owner. He's sitting
Very good,
right there.
thank you. Next, I will ask Code Enforcement Officer to introduce himself so that we are all aware.
Jason Williamson, Code Enforcement for Town of Raymond.
Thank you. So board procedures for tonight. When the Board of Appeals reviews a decision of the code enforcement officer, the board shall hold a de novo hearing. At that time, the board may receive and consider new evidence and testimony, be it oral or written. When acting in a de novo capacity, the board shall hear and decide the matter afresh, undertaking its own independent analysis of evidence and the law, and reaching its own decision. The person filing the appeal shall have the burden of proof. This hearing is being recorded. The board will follow the following procedures to conduct this hearing. Number one, the owner will present written or oral evidence or argument to the board. The board will then have opportunity to ask some questions with regards to that. Then CEO Williamson may present written or oral evidence or argument to the board and respond to the evidence or argument presented by the owner. Again, the board will have its own opportunity to ask questions of Jason. Then the owner will have an opportunity to respond to the evidence or arguments presented by CEO Williamson. Then the board will have opportunity just to ask questions further to get their own clarification. Each side will then have opportunity to make closing remarks of not more than 2 minutes each. There will also be public comment for this. So the chair will open public comments. Those who would like to comment in favor of the appeal will be given opportunity to speak first. Then those speaking against the appeal would be given opportunity to speak. And then finally, those just in neutral will have opportunity to speak as well. At that point, public comment will be closed. Both sides will have opportunity to have response to what has been given through public comment and to provide closing arguments. At that point, the board will then go into its deliberation on the issues before resolution, before the board, on the issues for resolution before the board this evening. The board shall decide all appeals within 35 days after the close of hearing and shall issue a written decision on all appeals. The chair will make evidentiary determinations as needed on the advice of the board's attorney. And this is an administrative hearing and not a court proceeding or a trial. Therefore, formal rules of evidence will not apply. So with this notice of violation or the appeal for, there has been a request to stay this appeal. That is not something that we typically have happen, so I'm going to ask our attorney to provide us procedural guidance on how we should move forward with that.
So there's not authority in the ordinance directly for a stay. The ordinance requires that after tonight's public hearing that the board issue a decision within 35, after the close of tonight's public hearing, after a decision within 30 days. Now, there's two, I think the board does have it in its authority to find a stay. First, you could table tonight's public hearing without closing it, and then the close of the hearing would be sometime in the future. That's probably the cleanest. If you think about the purpose of these deadlines in the statute and the ordinance, they're to make sure that the board and the town doesn't sit upon an appellant's appeal and never decide it and kind of keep things in limbo. And so in this case, we have the appellant asking for it. You'd want to hear where the town is and make a decision based on that. So short answer, it is odd, but it is something you could do under the ordinance.
Okay. So is that something the board will need to make a vote on in order to move forward with hearing the stay? Or I guess procedurally, what do we do for next steps with regard to just simply this request for the stay?
So this was noticed for public hearing. There may be members of the public who want to comment, and so it would be important, I think, to kind of go ahead, hear the basics of the appeal, get any public comment, and then the board can decide whether or not to table further public hearing.
Okay. So you have to bear with me here. I know we have a stay. Does the stay need to be addressed first?
I would wait to do that. If any members of the public came in response to the notice, you want to give them a chance to.
Okay.
Attorney Carey, may I make a suggestion? Mr. Chair, excuse me.
So yeah, so all comments need to be addressed to the chair, but certainly if
Sorry.
you have a comment to make towards this,
I have a suggestion for a procedure, and that would be that the board would entertain the stay first, and you could hear from me and anyone else who wishes to speak on the stay. And if because your decision on that would sort of govern how you'd handle the rest of the proceedings after that point. So as a threshold matter, I would suggest maybe discussing the stay first, and depending on how you decide that issue, then proceed accordingly.
Got a question, David?
yeah, go ahead, Rick.
If you're ready to take another one, I don't want.
No,
It's obviously related.
Yeah, no, please.
I just the clarification from council too, but I'll direct it to you. I understood that there's no explicit kind of ability to enact a stay, but there's sort of, if I understood what you said correctly, there's a constructive way in which a stay could be put in place by tabling the matter. Okay. I just want to make sure I understood that. And
So I would just say aloud as chair, my desire would be to move forward with the NOV, hear what's had to be said, take into consideration requests for stay, and then if the board decides, choose the method of tabling the matter if we feel there's reasons that come out as we're talking through this to table the matter. So that would be my preference to move forward. You feel good with that, Tom?
I vote for moving forward.
Very good. Okay. So we need to procedurally do a vote on that, or can we just?
You just proceed.
All right. So, Attorney Savinsky, we're just going to move forward with hearing the notice of violation. You can certainly bring forth any comments with regards to why we should table the matter, but we're going to move forward with hearing this appeal against the notice of violation.
Fair enough. Should I just proceed now, Mr. Chair? I'm
please.
standing here already. So.
Yeah, we're good to go. Please
Okay.
go ahead and make your presentation.
Okay, thank you. Well, first of all, on the stay, and I think Attorney Carey has it correctly, the procedure would be to just table this. And let me explain the reason why. This is a very kind of odd situation that really involves abutting landowners that the town was reluctant to get involved with. The certificate of occupancy for Mr. Stickney's residence was issued almost 2 years ago. Really, the board, I hope, received a letter from me dated yesterday, and I apologize that was the soonest we could deliver this information to the town. There's been a series of negotiations between Mr. Stickney and his abutters that have stalled. And in the course of our preparations for this appeal, we discovered there really is a legitimate dispute as to the proper location of the boundary between these two parcels at issue. And it's not a boundary dispute that this board has within its purview to decide, and nor would we ask you to make that decision. It's really something that a court ought to decide. So, with no other option, really, we were sort of forced into filing this complaint in Superior Court, seeking a declaratory judgment from the Superior Court as to the proper location of the boundary. And the outcome of that trial, or that determination by the court, would directly impact the outcome of this notice of violation. Because if the boundary is where we think it should be, it entirely moots the violations cited in the NOV. So that's the reason for the stay. But I guess proceeding from there, maybe it would be helpful for the board members to go through sort of the history of this property. I have Mr. Stickney here too, who can give us some factual details as to how it came to be. And if there's an easy way for him to come up here, could he share the podium with me? Or
Yeah, of course, definitely.
Yeah.
Yep. We just, because of recording purposes, we need to have somebody at the microphone and the podium.
Sure.
But
So
yeah,
maybe
if you
I'll
both
just-
want to share, that works.
We'll share. So Mr. Stickney can introduce himself here shortly, but this involves the construction of a single-family residence that began in 2023, and it was completed in 2024. In your materials, there is a certificate of occupancy from the town dated June 28th of 2024. Typically, if there is an issue with a building permit or a certificate of occupancy or an approval from the town, there's an appeal deadline that flows from that. Those have long since passed. But sort of after completion of the residence, sort of all parties involved really treated this as a non-issue until I think sometime after the residence was complete, despite having there been awareness of this construction project going on for over a year. So I'd like Mr. Stickney to maybe speak to some of those details. So I'm going to invite him up to the microphone right now. Go ahead and introduce yourself.
Hello, Mr. Chair. My name is Jonathan Stickney. I am owner of 34 Shore Road in Raymond.
David, this is Tom Hennessy. If I could they get closer to the mic or whatever, because I can't hear much.
Yeah, of course.
Is that better, Tom? Mr. Hennessy?
Yes.
Okay.
So why don't you start with the construction of the house, walking the property, take us back to 2020, April of 2023.
Sure. So I purchased the undeveloped lot on, I'll start before that, July 1st, 2022. At that time, before purchasing the lot, I was walking the back boundary and noticed there was a blazed tree line that marked from survey pin up the back line to the other survey pin. After I purchased the lot in July, sometime in August, possibly September, that blaze line was refreshed. Construction and clearing shortly began on my part in October, November 2022. During that time, I was leaving all permitting, things like that, up to my builder and GC. And the spring of 2023, the foundation was in the ground, walls were being built, and the building foreman was on site with his crew when the site was visited by Doug Morrell. And Doug talked to the building foreman, commented on the house location, but did not say it was in a bad spot, and also gave further permission to cut down trees that any deemed hazardous to falling on the house. So with that permission, an additional tree was cut down. It was the tree that the board witnessed at the site walk that was hollowed out. From there, the house construction continued to go forward. Sorry, go ahead.
What's the next interaction you had with anyone speaking on behalf of the property owner?
The next interaction I had with anyone representing the property was with Doug Morrell in late spring 2024. He showed up to my house to discuss a issue that had become common between the two road associations between Thomas Pond Terrace and Shore Road, which was where each of those roads dead into a line of boulders, which are at the base, the front left edge of my property. Those boulders prevent passage between the two roads. And his question to me was regarding if I was in favor or not in favor of removing those boulders for allowing a fire department gate being put in for allowing fire trucks to pass between the two roads. I was not in favor and still am not in favor of that. And then that turned into a kind of a sidebar comment from Doug asking if I think he said the Road Association president noticed when he was looking at aerial survey pictures that he thought that my house was built on to his children's property, and he stated right then that he did not think that I did. I did find that comment kind of weird, but a week later he showed back up to my house with a GIS image showing what the apparent violation was with my house being built on the property. I'd have to recall through notes exactly the details of that, but then he came back a week later with a further demand of monetary payment.
We don't have to get into that. That's just thinking, but I'm trying to think if there's anything. So you had a survey commissioned at some point.
Correct.
After all that came.
Correct. After this came to light, I started calling around to multiple survey companies, and honestly got the first one who could do the work the quickest. So as soon as that work was done, I willingly shared that information with Mr. Morrell, Doug Morrell, and also with the town, to which I brought it to the.
Yeah, who did you share that with at the town?
So I brought it to the code office and also with the tax assessor. I was working with Kurt Leibel, I believe he was the assessor, because I was told that I need to talk to him to figure out, because the lot was in tree growth, what the tax penalty might be for pulling the slot of land out of tree growth.
Who was the code enforcement officer at the time?
I do believe it was Chris Hansen.
And what did Chris Hansen do after having seen that survey?
The recognition between the code office and myself, the discussion was that we were handling this civilly and we're trying to work through this through third party, and that the town was going to wait to see if any resolution could happen from the civil matter. And that was the case. Got a phone call from Chris Hansen December, I think the week of Christmas or the week before Christmas, 2024, asking what the status of the issue with the Morrell property was, and my response to him was we had been trying to actively work on resolution with the Morrells, but they had not been willing to even negotiate with us.
Have you ever had any interaction with Brittany McNeil, Aaron Morrell, or Brendan Morrell?
I've never spoken with them directly. I have received certified letter from them, and the first time I do believe I actually have even seen one of the Morrell children, I think it was Brendan, was at the site walk this Saturday, whatever date that was, whenever the board was there.
21st. Okay, thank you. So, as Mr. Stickney mentioned, the abutting property that's involved here has been in tree growth status, and according to the town files, since at least 1975. And when a property is in tree growth status and you want to harvest it, there's a requirement to mark the property lines. So that was done at some point because the property was harvested at some point many years ago. And the line that was marked appears to correspond exactly to the flags that the board members saw on the property at the site walk on March 21st. So that's, and this is all subject of further investigation, but it appears that blazed line that the board members observed on the 21st has been in existence and treated as the actual property boundary since at least 1994 and possibly since 1975. So that is the subject of the civil litigation, which has been initiated, seeking a judicial court order remedying this situation. So with that, I think I'll leave it at that, and if the board has any questions, I'd be happy to answer them.
I do have some questions, but I gotta get my notes down here. I guess number one is we are meeting here tonight with regards to the notice of violation. What specifically are you asking what the board to do with this notice of violation?
I think the outcome of this appeal hinges upon what the court will decide in the related litigation between the two property owners. So this is really a boundary dispute, which has become a town dispute because of the issuance of the notice of violation. So the town doesn't need to get involved at this stage. If the court agrees with us, and the boundary is where the blazed line is, there is no violation. And the substance of the NOV becomes, in my view, entirely moot at that point.
When did Mr. Stickney receive the survey? The survey from mainland?
It would have been middle of July 2024.
Okay, so I do know it has a submission date on it of,
I believe, if I'm not mistaken. It was either June, mid-June or mid-July. I can't remember.
it has a submission date on it of June 13th, 2024. Would that be right around the date that you received it?
If I received it on the 13th, then I would have submitted it to the town within the next day or two, yes.
Okay, because that was my next question, is when did you make the survey available to the town?
I would have to verify through my notes on that to figure out the exact date, but it would have been right around that time.
Is your contention then that this survey is inaccurate? Or what is your opinion on this survey?
First of all, it was commissioned for Mr. Stickney, and the town is using it as evidence in its notice of violation. A survey, and I'm not a surveyor, but it wouldn't take into consideration matters such as a claim of boundary by acquiescence, which is the subject of the civil litigation. So, like, a court has the jurisdiction to resolve a boundary dispute, which might, result in a boundary being different from what is depicted on the survey.
Because I do note on this survey, there's at least 1, 2, 3, like 5 pins, pre-existing pins noted. There's also plan references to it's probably like subdivision plans that were surveyed and filed, recorded, 1928, 1956, and as well as 1956. I guess, given the survey, given the survey, would you agree that the structure is encroaching as well as within setbacks?
I mean, the survey says what it says. I'm not going to argue that.
Okay.
The survey doesn't depict an encroachment. That's what it depicts.
Okay, and I still think I would like to get confirmation of you what specifically you're asking the board to do, outside of a stay. What specifically you're asking the board to do with regards to this notice of violation?
Well, if you were to table the public hearing, then you would not be making a decision on it one way or the other. And Attorney Carey can explain it better than I can. The reason why is because, well, if a court determines that the boundary it should be other than what is depicted on the survey that impacts the violations alleged in the NOV.
I'm going to open this up to the board. Sorry, guys, I've been kind of hogging things. So.
You got something? Go ahead.
I'm good at the moment.
Can you, Jonathan, you'd mentioned the blaze line refresh. Can you elaborate what that means? I think either prior to or just after purchasing. You explain that in a little bit more detail.
Sure. So when I was walking the property before purchase, and even at purchase, there were definitely some, like I said, like aged blaze marks. But then those blaze marks were refreshed with fresh blaze paint.
Okay, just so I want to just get the chronology correct. So when you purchased it, they were aged.
Correct.
And after you purchased it, they've been refreshed.
Correct.
Were they the same marks?
Yes.
Like, was it somebody go in and touch up the aged mark, or were there two sets of different blades?
It was the blaze line on the same tree line.
It's on the same. Okay.
I couldn't say for certain because I didn't mark each tree to see
Right.
which ones had been, but it was the same line.
Okay.
My apologies for interrupting. Greg, could you turn your mic towards you
Oh,
more?
sorry.
Thank you.
Do you want me to repeat my question?
No, I picked it up. I turned your volume up.
Okay. And then I think maybe for council, could you just walk us through like very specifically the timing of the case you have pending in Superior Court, I guess, when that was started relative to the NOV, relative to your filing the appeal? Just trying to I want to make sure I have the chronology correct.
Yeah, well, we had tried to avoid filing the civil suit, but we're sort of the NOV, I would say, forced the issue.
Yep.
So that was January. So we sort of had to file this appeal to preserve Mr. Stickney's rights, and with no private resolution available in the short time period between when the NOV was issued and now, and also as a result of further investigation into the town records documenting that this blaze line has existed for several decades. So to answer your question, this was just filed with the court on Friday or Monday yesterday. So
Okay.
it's
Which one is it?
well, we mailed it out on
Okay.
Friday.
All right. Friday.
So they probably got it.
They
on
got it.
Monday.
Okay. All right.
Yeah, the cover
So,
letters.
just so
the
I
cover
understand-
letter to the court is right
Yeah,
in the.
just trying to get it from your perspective. The
Yeah.
NOV comes in January.
Yeah.
Appeal to make sure you get the appeal in to the
Yeah.
board, and then kind of as a side parallel effort, working through civil matters to try to address the threshold issue, which is the border dispute itself.
Right.
Thinking that if that is resolved, it would certainly lend
It would
guidance
be
to the decision.
It would be dispositive of the
Right.
NOV.
Exactly. Yeah. Okay.
Yeah.
Fred, Tom?
Guess my only question is, I wasn't present on the site walk. Are you planning to read that off into the minutes? Or
You know what?
do you?
Yeah, that was an oversight on my part, Tom. You are correct. We do have a site walk report, which Pete recorded for us. I'm going to go ahead, Pete, you go ahead and read it out.
Sure.
We will vote to accept it and include it in the record. My apologies for that.
That's okay. And my question in the is also, the survey shows a number of things, but it does not show the septic system. If you have any insight from the site walk that says it's on one side or the other of the property line.
Yeah, let's go ahead and have Pete read the site walk, and then if that's still an outstanding question, we can clarify for you. Go ahead, Pete.
Okay, Zoning Board of Appeals site walk, Saturday, March 21st, 2026, scheduled for 9 a.m. Attendees from the ZBA members was David Murch, Greg Dean, Fred Miller, Pete Lockwood. Tom Hennessy was not in attendance. Other attendees were Joe Savisky, Doug Morrill, Dennis Martin, Teresa Ellis, Brandon Morrill, Jonathan Stickney, and Sheena Randall. The site walk started at 9:03 a.m. David provided the guidelines for the site walk. We started walking the property by heading from the driveway around the east side of the property. In the easterlymost corner of the backyard, Mr. Stickney pointed out the pink ribbons, flags that were tied to several trees. David asked if the rock wall was existing or if it had been built as part of the house construction. Mr. Stickney responded that it was not pre-existing, but it had been recently constructed. It was discussed that the flags were pre-existing. Mr. Stickney commented that they were. It is clarified in our ZBA packets that these are not the actual property line. From the lawn in the backyard, we stepped 10 to 15 feet into the woods, and Mr. Stickney pointed to a large tree on the ground which had originally been thought to be a property marker. From this point, Mr. Stickney pointed to a tree to the west, which has a red blaze painted onto it along with a pink flag. Mr. Stickney indicated that the back property line was originally thought to run from this tree to the flags on the east side of the property. We moved back to the lawn and headed to the west side of the backyard. David pointed to a generator and a propane tank and indicated that the generator was noted as the HVAC in the survey. We then moved around to the west side of the lawn where two other pink flags were noted. These are not property lines, but are relative to the septic system. Mr. Stickney mentioned that we were standing above the septic tank. We walked from here around to the front of the property and back onto the driveway. Mr. Doug Morrill asked if we wanted to see the property line between his property and Mr. Stickney's. David said that he was all set. Nobody else from the ZBA indicated that they needed to see the property line either. This concluded the site walk. The site walk ended at 9:15 a.m. Respectfully submitted, Pete Lockwood.
Board members that are here in this room that were in attendance on the site walk, do you have any anything that you would want to alter, comments? So, all those in favor of accepting the site walk report into the record? David Murch, yes?
Greg Dean, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Tom, you're going to have to abstain.
I abstain.
Very good, so that is in our records. So Tom, does that help to answer your question with regards to where the septic was?
It's from that, it kind of sounded like it was within the surveyed property lines.
I would agree to that, but I will seek confirmation from my fellow board members.
David,
Within, yeah.
Yeah, within, I can't vouch to within, the established 30-foot setback on this, but yeah, within the established property boundaries.
I don't think the 30-foot setback applies to septic systems, but yeah, as long as it's not way outside the property line, that's all I was trying to figure out.
Fred, did you have anything from? No? Okay.
Can I just ask a follow-up
Yeah,
question?
of course you can.
Sorry if I'm not trying to belabor the point, just trying to understand. I'm not familiar with court process, like mailing, how that whole process starts. Can you just walk me through? It does strike me as very late in the end of March to be getting this in front of the court. Can you just explain the timeline of how it gets to being filed on Friday, potentially received Monday before this board hears the violation?
Yeah, well, I mean, it was my litigator colleagues prepared the complaint and filed it. It was a matter of last resort.
Okay.
That's all I can say.
So there was some work being done trying to make progress.
Yeah.
Okay.
Yeah, I mean, a considerable amount of research and investigation went in. It wasn't something that we just, scribbled down on paper and ran it over to the courthouse. This was several weeks in the making.
Okay. Thank you.
So we're going to pivot now. We're going to give Jason a chance to present his side of things. So certainly feel free to take a seat. And Jason, if you want to go ahead and present to us what you have, please.
I mean, I think you got the memo that I put out March 18th. It spells most of it. I can just go over a quick timeline of what I see what happened. It looked to me, and I was going through the permitting. Initially, permits were applied for back in 9/9/22. They were put on hold. The note I found was for a tree permit to cut down the trees. Then there was nothing that happened. On 1/11/23, a septic inspection was called in. The code officer at the time, Chris Hansen, he went down and noted that there were no permits that were issued at the time. The applicant had dropped off the permits, but they hadn't been approved nor paid for at that time, except for the driveway permit. So after the fact, permits were, and he noticed.
Well, can you go smack that ball on the table to shut it
A
up?
foundation was also going in.
Yes.
A septic design was applied for on 3/15/23.
Atta girl.
And all the permits looked like they were issued on or about 4/19/23. All the normal inspections took place. I think you have the
Right.
plot plan that was submitted with the permit application showing that that setbacks to with a wide margin. Certificate of occupancy was written 6/28/24. I began working at the town of Raymond on July 9th, 2024, and I remember Mr. Stickney coming in with the survey, saying that he realized there was an issue there, and what to do about it. We were sympathetic to him. We understood that a mistake had been made, and thought the best course of action at the time was to not issue any violations and to let the parties work it out. So I wasn't privy to the call that Chris Hansen made in December, but in August of 25, it had been a year and there had been no progress that we had seen. So a warning letter was written, just kind of getting on the radar there to let them know, this is an issue. We recognize it as such. Didn't want to have to write an NOV, but another 5 months had passed with no resolution, no information. The town doesn't like to take sides in these matters, but the longer this went on, it felt as the town was taking one side of what, admittedly is partly a civil dispute. We're not surveyors, we have we get a survey that shows a line. We have to respect that. Ultimately, it came down to writing the NOV in January.
sorry.
No, go ahead.
I was just going to say, so the reluctancy was just about trying to defer town involvement, hoping
Correct.
that
It had just been,
ambiguity about there's no ambiguity about from the town's perspective.
it had just been noticed. Mr. Stickney seemed genuine in wanting to get it resolved, so the thinking was, let's give him some latitude here. Let's give him a chance to fix this before, the town would take action.
Has that was it just a matter of time that made that opinion
Time
change,
and
or is it different now, or are there new from your perspective?
I think at a certain point, how long do you let it go? We can't convey property rights through a certificate of occupancy. Ultimately, we have a situation here where not only is there a setback encroachment, but it was onto another property. So now you have two residents who are in disagreement. Ultimately, whatever we do is going to look like we're taking one side or the other. We felt the prudent action would be to give the parties a chance to work it out. But as time wore on, I hadn't heard anything. Maybe if this court had been filed and said, hey, listen, there's a serious property line dispute here, take that into consideration. There was none of that. We're kind of left with the facts on the ground at that point, and had to make a decision at some point.
But now that has been filed, does that change your opinion on the status of, or the appropriateness of the NOV?
You never know what could happen at court. And even although, I've looked at that survey, and if you connect those 2 points on the line, I'm still not sure that setbacks will be met. We're talking about a line that is defined on a survey versus a theoretical line that we don't know where it is. We don't know if the court would determine that line does meet setbacks or where they would put that line. We have to go by the survey.
The survey that the property owner provided.
Yep. We were going off the plot plan that was given to us, which showed setbacks met fine.
Right.
And it says, on the bottom of every single one of our permits, it says, the approval of this permit is in no way relieves the applicant of, the applicant has the burden of ensuring that he has the legal right to use the property and that he's measuring required setbacks from the legal boundary lines on the lot. The approval of this permit in no way relieves the applicant of this burden, nor does this permit approve constitution of a resolution in favor of the applicant of any issues regarding the property boundaries, ownership, or similar title issues. It is hereby certified that the above use as shown on the plats and plans submitted with the application conform with all applicable provisions of the Town of Raymond Land Use Ordinance and shoreline provisions. So when the C of O was issued, it was issued with the information that we had that everything was fine. When we get that,
David, this is Tom. When I can ask a question to Jason, I'd like to.
Okay. Do you feel like you had a chance to answer?
Yeah.
Okay. Go ahead, Tom.
I looked at the survey and I looked at the building sketch of a plot plan, and those measurements agree pretty closely with the actual survey, the plot plan, the building permit sketch, I'll call it, and had measurements on it, and they seem to agree pretty closely with the measurements that were actually on the survey done. And it did depict a sketch of a house, basically in the dead center of the property. Somehow, I don't understand how we could go so wrong to go that deep and go off the property line and base it on some pink flags. I didn't go to the site, so I don't really know exactly, but that just, if you can clarify, do you agree that the building application and the sketch that was there agrees really closely with the actual survey?
You're asking if the plot plan that was provided how closely it aligns with the survey?
Yes, not inches, but,
I'd say, let me just pull up that, just look at them side by side. I would say the driveway is more indicative of where the house location on the plot plan shows. You know, it's showing the house 275 feet from the, what I would call the, if you're standing on Shore Road, the right sideline. You know, that can't be more than 120 feet. So, you know, that's a 150-foot discrepancy right there. And it's showing 60 feet from the front, and you can see a 30-foot front setback. That's got to be 111 feet, 110 feet, 100 feet or so. So there's clearly discrepancies there, but, you know, we don't do setback inspections. And that's why we have that written in the permit. You know, we don't necessarily require a survey for a lot unless it's close on like lot coverage or property lines. This one's showing 38 feet from the back, 60 from the front, 70 from the side, 275 from one side. I wasn't involved in the permit review on this one, but you know, that shows, you know, it's meeting fairly comfortably.
so did I get out of that you agree that the sketch that was attached to the building application pretty much agrees with the dimensions of the survey?
Are you talking the outside dimensions?
Yes, the outside.
Yes, 80, 110, 160, 150. Yeah, they're within a couple feet.
Yeah.
The biggest discrepancy you see is about 3 or 4 feet.
Yeah, and it depicted a short driveway and a house dead center in the property.
The plot, the supplied, the applicant's plot plan, yeah, it shows it. No, it did, the measurements don't, the drawing shows it in the center, but
Yeah.
if you read the 275 on one side and 70 feet on the other, I don't know if that's supposed to be 70 feet to the driveway, but, you know, just looking at that, you know, those, if you add up 110, 90, and 90, you have 300 feet. So, yeah, that's 300 feet. So 275 from that sideline is, I don't know how they came up with that number. Maybe that's the whole width of the lot. I'm not sure. And it's just not depicted properly.
Okay.
A couple of questions, Jason. Does the issuance of a certificate of occupancy override any subsequent zoning violations that are found?
When they're found after it's issued,
Correct.
I think if it's found after it's issued, you know, it was issued in error at that point because it was issued on information that was incorrect.
No, I'll probably restate that. Does the issuance of a certificate of occupancy somehow trump over, does that help? If zoning violations are then subsequently found, does the issuance of a certificate of occupancy override those zoning violations, meaning that you can now ignore them because a CO was?
I don't think so.
Okay. So basically, if I'm understanding you correctly, if a zoning violation is found, regardless of a certificate of occupancy, that zoning violation needs to be acted upon.
Yeah, I guess it does.
Okay. But
And that's why I started with the warning letter at first.
yeah, 'cause part of this is what I come to is I did review our ordinances, and in shoreline zoning, we have Article 7, 350-7-8, enforcement. It says nuisances, any violation of these ordinance, defines a nuisance. Any violation of these ordinance provisions shall be deemed to be a nuisance. And then, right after that, B, code enforcement. Number 1, it shall be the duty of the code enforcement officer to enforce the provisions of these ordinance provisions. If the CEO shall find that any provision of these ordinance provisions is being violated, he or she shall notify in writing the person responsible of such violation, including the nature of the violation and ordering the action necessary to correct it, including discontinuance of illegal use of land, buildings, or structures, or work being done, removal of illegal building or structure, and abatement of nuisance conditions. A copy of such notices shall be submitted to the municipal officers and be maintained as a permanent record. Now, there is no timeline to that. It just simply says that you need to act on it. Would you say that that has been acted on? Would you say that this has been, the issuance of the NOV?
I say I acted on that, yes,
Okay.
I would say so.
Are you aware of any sort of like expiration date on a zoning violation, you know? Like, thank you, statute of limitation. I couldn't think of the right word.
No, I don't know of one.
Okay.
You know, you never know when you're gonna get notified of a violation. And, you know, I don't think it's unusual to get notified of a violation and not, you know, and try and reach out and with a warning letter or something like that to try and get a resolution.
Sure.
And give the homeowner or property owner or whoever a chance. When I started doing code enforcement, they said, you know, try not to be too helpful. It's a hard thing not to feel for people sometimes. So, you know, when somebody's got a violation, my philosophy is give them a chance. So that's what we had here. Whether I should have acted on it right away and revoke, well, I wasn't in the position to do that. I was only the assistant. I had just come on. So I wasn't in the position to act within, if you want to consider, you know, needing to act within 30 days as kind of de facto appeal of that. I wasn't in a position to do that at the time. So I was content to follow what the previous code officer did and say, you know, let's wait on this, and give them a chance, these two parties, to work things out. But as time went on, it got the feeling that this may drag on forever. And at what point, you know, when you have another property owner, budding property owner, you know, asking questions, wondering why we're not looking out for their rights, puts us in the middle of a civil dispute. So a decision had to be made, and I made a decision.
Okay. A couple other questions, and I'll give you guys a chance to if you have something. But just reading through the notice of violation and looking at the survey, I'm going to ask you some questions. I pretty much know what I think your answers are going to be, but based on the survey, notice of violation, you are still in agreement that there is encroachment occurring, and you are still in agreement that there is a setback violation with regards to the property.
Yes.
Specifically, Chapter 350, Article 6, 350-6-2, minimum lot standards and setbacks. Minimum building setback shall be as follows: front 30, side 30, rear 30. And it's the rear 30 that we're speaking to, correct?
Rear 30, yes, correct.
Okay. There are two things noted, well, actually three, I guess. Enforcements. There is number one, removal of the portion of the structure that does not meet setbacks, or relocation of the structure to meet setbacks. Are you still in agreement with that as an enforcement?
I mean, I
option?
only see three ways to go about this, you know, lot line adjustment, removal, or relocation. You know, if this had been a non-conforming lot abutting, I would not have suggested a lot line adjustment, because it would not have been we can't make a non-conforming a lot more non-conforming. So that's why I offered that up, as I couldn't think of another way to meet setbacks.
Got it. So looking at, 350 Article 7, 350-7-8, including discontinuance of illegal work, removal of building structure. So, and then, so the second option you give is legal resolution of the encroachment through a recorded lot line adjustment approved by authority having jurisdiction. Are you still in agreement with that? Because in the original paperwork submitted, that the attorney for Jonathan Stickney indicated that's more of a civil issue and not really anything that the town can enforce.
No, but when we write a violation, we try to give all the options that are available to them. You're correct, we can't make both parties agree to a lot line adjustment at all. But, just felt it's our job to try and give the person every option available.
And one last,
I mean, to that note, that point, we can't, like I said before, we can't convey land through a certificate of occupancy either. So, we look at that, and a lot line adjustment, it's easier to move a line on paper than it is a house.
so the removal, in your opinion, is something the town can enforce. The legal resolution is not anything that the town can enforce. Would you agree with that?
Yeah.
Okay. And then the last option is number one or two, removal or legal resolution, and with those, and submission of all required applications, plans, surveys, and permits necessary to resolve the violation. You're in agreement with that enforcement action? Okay.
We would need a new building permit to relocate.
Gotcha. And finally, in your memo to the board, you did have a section 3, so what the CEO is asking the board to do. I'm going to read them. I'm going to give you my take on them. Mm-hmm. May ask our attorney to help with this as well, but I'll read out loud. Said the CEO asked the board to deny the appeal, uphold the NOV in its entirety, and direct the following corrective actions. 1, remove the encroachment. The owner must remove or relocate a portion of the structure on the abutting land or legally require a property interest in that land. For example, through a recorded boundary line adjustment with the neighbor's consent. Number 2, revoke or suspend the certificate of occupancy. The board may wish to confirm that the certificate of occupancy is suspended or revoked pending full compliance consistent with state law. And then finally, number 3, assess penalties. Under Maine law, per violation, penalties range from a minimum of $100 to a maximum of $2,500 per day. And the willfulness of the owner's conduct, building without permits, not verifying boundaries, may be considered in setting the amount. Number 1 seems outside our scope. That's a civil issue. Number 2, again, that's an enforcement action, which is really, I don't think the board has the authority to do. And assess penalties, again, I think that's more of a select board issue. And so I believe that all 3 of these are outside the authority of the board to consider. I will ask our own attorney who's advising us if that might be the case, but I want to address these 3 points with you before we go much further. I will, but yeah. Did you want to voice any of that?
Yeah, so what you're asked to do is to consider whether to revoke the notice of violation or uphold it. You don't have the authority. So the code enforcement officer talked about the 3 different remedies that are available.
Yep.
Any of those would cure the violation. He doesn't necessarily have the authority to order a specific remedy other than removal. Okay. He can order the removal. He can observe that any of the 3 would cure the violation. The effect of that is that curing the what's the difference? curing the violation means if there was a lot line difference recorded, there would no longer be a violation. So if a court found per day penalties, that would stop at the date that the lot line agreement was recorded or the house was moved. And so they would go into the amount of civil penalty if the violation was cured. But he doesn't have the authority to order 2 of the 3.
Okay.
In terms of your other, I don't think that
These are the 3 that he had brought to us outside of the NOV.
Yeah, the I mean, so you're upholding NOV, and so there may be a second. So the revocation or suspension of the CO isn't part of the NOV. That may be some authority that he could do next, but that's not, because that was not part of the NOV. That's not on appeal here. He does mention the assessment of penalties and recite the statute and the ordinance that authorizes penalties. And so that is the next, it is a court that would determine how much civil penalties to assess and whether to also award attorney's fees as damage. And also as a technical matter, the specific performance it required is also considered part of a penalty. And so the next step in a notice of violation would be going to court and enforcing what the penalties for that would be. And that, as you point out, that suit would be authorized by the select board, not by this body here. So what you can do is observe whether or not the violation that's noted in the NOV is accurate and whether or not it violates the codes that are cited. And that's what you would do here. And then it would be the select board that would determine how to enforce it going further.
Got it. Thank you. Any questions for Jason? Okay. So what I'm going to do is if Mr. Stickney, you or your attorney have some counter points to make, certainly feel free. I'll give Jason a chance to do a counterpoint to that, and then we're going to open this up to public comments. Nothing? Okay. So I'm going to go ahead and open this up to public comments. We will do first through here in the broadcast studio, and then we'll move to Zoom land. We're going to first open this up to those who want to speak in favor of this appeal. Is there anyone here tonight that would like to speak in favor of this appeal? Is there anyone on Zoom or who's called in that would like to speak in favor of this appeal? Okay. Now I'm going to go ahead and open it up to the people here in the broadcast studio first. Anybody who would like to speak against this appeal? And again, if you are speaking, try to focus specifically on the issues at hand, and again, speak your name, affiliation for this, and who you're representing, where you're from, please.
Thank you, Mr. Chairman. Members of the board, my name is Jason Theobald. I'm an attorney with Curtis Thaxter in Portland, and I represent Aaron Morrell, Brendan Morrell, and Brittany McNeil. I believe Brendan is on Zoom attending tonight. They're the owners of the abutting lot, tax map 6, lot 30, which is the tree growth lot on which Mr. Stickney's property is encroaching. And the property is also being encroached upon by additional fixtures of the property, notably the propane tank and the generator unit that's marked as an HVAC on the survey. As the owners of the abutting property, the Morrells are obviously interested parties in this action. They're the ones being encroached upon, and they're, aggrieved by this process. So they are very much interested in the outcome of this appeal. Also with me is, and to be clear, Also, I want to be clear that the Morels have not consented nor acquiesced to the encroachment onto their property by Mr. Stickney's house or the fixtures associated with it. Also with me here is another abutter, Doug Morel. He's the father of Aaron, Brendan, and Brittany, the owners of the property being encroached upon. Doug's the owner of the property at 201 Thompson Pond Terrace, which abuts Mr. Stickney's property to the south on the other side. Although his property is not being encroached upon, as a direct abutter to Mr. Stickney, he's obviously interested in the outcome of this appeal. So just for the record, as the chairman pointed out, I'm up here as opposed to the appeal. We are in favor of the NOB being upheld tonight by the Board of Appeals. And so I just kind of want to go through and address some of the different arguments. I'll start with this issue of the stay, since that's where we started at the beginning of the night. And so we're opposed to stay. We believe that the board has all the information it needs tonight to make a decision upon the issue of whether the NOV itself was properly authorized and should be upheld. Mr. Stickney's attorney have asked this be stayed because they have recently, although they had previously asked for a stay under some other grounds, they have now kind of focused on the idea that they have now filed a civil action against my clients. I've seen the complaint. We have not been served the complaint. Just to answer some of Mr. Dean's kind of questions about the process, is typically after a complaint is filed with the court, the defendants have to be served. That can take some time. So we officially have not been, though I'm aware of it, we have not officially been served with it. So we have not technically been brought into the legal process yet. Once we are brought in, the timeline for how that plays out is unclear. More likely than not, we'll be filing a counterclaim. And then kind of once you're in that process, it can take months, years to play out before anything happens. You know, the idea of tabling this meeting pending some kind of outcome there is really an unknown. I mean, it could be tabled for quite some time. And frankly, that's not necessary. And I think one of the reasons it's probably not necessary is the civil process, which has been started in the courts, and what this board's job is and what the CEO's job is in issuing a notice of violation are two different things. The purpose of the land use ordinances that the CEO is tasked with enforcing, they are intended to maintain the character of the town of Raymond. And so the idea of having setbacks and having certain land use requirements is in order to maintain a certain aesthetic to the community, a certain lifestyle that the town deems appropriate. And so when the CEO sees violations of ordinances, it's not necessarily to vindicate the private rights between neighbors or abutters. What it is to maintain the standards of the town. And so here, regardless of what happens with the private dispute between my client and Mr. Stickney about the settling the encroachment, the fact of the matter is the setbacks aren't being complied with, and that is the town's primary concern, is whether or not is its ordinance being followed. Now, a settlement or a resolution of the judicial action might resolve that. That is, as we stand here tonight, unknown. But the fact of the matter is this town has to focus on whether or not its ordinances are being enforced. And I think it also has to think about, if it's not going to enforce its ordinance and it's going to table those kind of decisions, you know, while neighbors settle out private disputes, the message it can send to, you know, others in the town about how the town's in dealing with these things. And so I think the town has an incentive and an interest in ensuring that its ordinances are broadly complied with. And really, again, the civil action has no real bearing on whether or not, you know, as we sit here tonight, whether or not the setback requirements in the shoreline zoning ordinance are being complied with. And I think the board has all it has in front of it. It needs to make that determination whether or not the notice of violation was properly issued. And so, you know, so there's been a lot, I think, made out of the history of this and the blazed lines, and I kind of want to talk about that a little bit. So the Morels property is a tree growth lot, and as part of being enrolled in the state's tree growth program, the trees and the cutting of it and the management is subject to a forestry management plan that has to be renewed every so many years. And as part of that, one of the requirements is that for any cutting, and this is my understanding, is any cutting, there has to be, the property needs to be marked the boundary lines to ensure that no cutting is accidentally cut onto somebody else's property. And so as part of that, the lines have been blazed in order to ensure that the cutting doesn't come onto Mr. Stickney's or another neighbor's property. But just because it's been blazed for the forestry management piece is not determinative of where the property line is. That's just to ensure that they stay on the Morel's property. It's not determinative of where the boundary is. The boundary is obviously determined by the deeds and what the deeds have in the plans for these particular subdivisions where Mr. Stickney's property is, that were recorded many years ago. They're the ones that ultimately determine where the lines is, and the surveyor who did the survey, that's what they looked to. And so even if there was a mistaken belief that the property line was somewhere else and that was mistaken based on the blazes, it doesn't change the fact of where the actual property line is. And I'd also like to point out that a lot of this, I think, issue is somewhat of self-created harm, whether it was created intentionally or it was by a mistake, and it may have been a mistake done by not Mr. Stickney himself, it may have been done by his contractor. But I may have Doug come up here and speak too, because Doug knows more of the details of the history of this, but my understanding is that, and I think the CEO had talked about this too, is that cutting had been started on Mr. Stickney's property as part of the construction without permitting. And when it was realized that there was work going on that was unpermitted, there was a stop work order issued, and Mr. Stickney applied for an after-the-fact permit. He could have, at that point, gotten a survey to ensure he knew where the property lines were before the permitting done, and so to ensure that he was locating the house on the correct spot. There was no survey done, and whether the builder made a mistake or an error, ultimately the house was built not in the location it was. And as I think there was a discussion earlier about the drawing that was in the build permit showing the house located kind of dead center. As I pointed out, some of those measurements on that map are not correct. It does say it's 275 feet from the sideline, which doesn't make sense when you consider that the line along Shore Road is roughly 300, so the house couldn't be dead center and also be located 275 feet from the property line. But I think also when you look at that drawing in the build permit, you'll see that the house is oriented lengthwise perpendicular to Shore Road. And then, but the actual construction, which I think you can see on the survey, the house is, the way I see it, has been turned 90 degrees a different direction, and now it's lengthwise running north-south, I believe, or maybe east-west at that point. But either way, it's running a different direction than what was on the build permit. So it does not seem to be that it was built in accordance with the permit that was requested. Again, whether or not that was a mistake or an error, an innocent error, we can't say. But the fact of the matter is it was not built in conformance with the permit. And so this idea that the certificate of occupancy was then issued and that somehow that's the town is a stop from enforcing its setbacks because it issued a certificate of occupancy, I think it runs counter to the fact that this is a self-created issue. That the permit application makes very clear that they're not deciding, they're in the fine print there at the bottom, although it's not really fine print, but at the bottom there, the kind of warning that the CEO pointed to, that the permit application is not making any kind of decisions on location and lot lines, that they're only issuing the permit based on information provided, and that's the landowner's responsibility to ensure that the setbacks are complied with. That clearly didn't happen in this situation. And so, just because a certificate of occupancy is issued, I don't think relieves the landowner, from having complied with the setbacks given that warning. And I think I'm jumping around a little bit here, but another point I kind of want to make on the enforcement piece and to what extent the ordinance allows the CEO to enforce land uses after their certificate of occupancy. I think in Mr. Stickney's submission to the board with his appeal, they focus on section 300-5.5 of the land use ordinance, which talks about a certificate of occupancy shall be issued by the building inspector, or in this case, it's the CEO, determining that the building and structure and the land complies with the ordinances. However, I think, and I think there's been some suggestion that essentially that this means once a certificate of occupancy is issued, it's somehow blessing compliance with those land use ordinances. And I don't think that's a correct reading of the ordinance. I think it talks about what is done to get a certificate of occupancy, but I think it has to be read in conjunction with the other parts of the statute. And I think particularly it has to be read in conjunction with section 300-5.8, which then talks about the code enforcement officer shall, if the code enforcement officer shall find any provision of this chapter is being violated, then the code officer shall notify in writing the person and shall issue a notice of violation. So I think that clearly indicates that if any kind of violation, whether after certificate of occupancy or any time is determined, it's the obligation of the CEO to issue a notice of violation. And I think that's what's been done in this case. So there's no exception in that particular section for if there was a certificate of occupancy issued in the past, or if there was some kind of other permitting issue in the past. It says if there is a violation, then the CEO shall issue a notice of violation. And so I'm going to actually get Doug to come up here and talk a little bit, because Doug, like I said, I think Doug, we heard a lot from Mr. Stickney earlier about the timing of things, and I think our position is the timing of things is different than I think what's been presented to the board.
Good evening. My name is Doug Morrill. I'm an abutting landowner, and I am against granting the appeal or the stay. This has been going on for quite some time, as you well know, but the discussions with Mr. Stickney have been very amicable over the time, but they just don't, they stopped in the fall of 2024. So at least getting him in the room with us and having the opportunity to work something out down the road is beneficial. Back to the original survey that Mr. Stickney had performed, I was the one that recommended that was a good starting point for us. Let's figure out where the lines are. Let's figure out where the house is. On the town tax maps, it shows lot 101, 102, 103. Those were established in 1956 in a town-approved subdivision. As you can see on those sketches, each of the lines are marked with a distance, and each line is angular in some fashion. But it's got nothing to do with the cruise lines on the back that a forester established. He's not a surveyor, the forester. He's looking for tree types and what areas are wet, where the deer wintering yards and things like that. Not a boundary survey. So there was a surveyor on the road that happened to be doing some work in that same time frame. I went down and chatted with him. He was doing some work right in front of the Martin's house and Sheila Randall's house. And chatted with him, and he said he could be happy to come look at it, but couldn't get to it for a while. So Jonathan and I chatted about that and decided that, he decided he could make a couple of phone calls, and that was on May 22nd. 3 weeks later, he had a survey in hand, the survey that you see in front of you. If you look at that survey, the interesting part, and we keep talking about this blaze line in back that the forester did, the issue is that iron pin that's 20 inches high on the southeast corner, which does abut my land, and it abuts Brendan, Aaron, and Brittany's land. And by the way, excuse me, Brendan and Aaron are on the video tonight. Brittany is in Arnold, Maryland, trying to put 2 kids to bed, just outside of Annapolis. Brendan's in New York City in a hotel room on business, and Aaron's in Cape. They don't get up here much, except in the summertime. Brittany comes up for about 6 weeks in the summer, each summer. But they're around virtually every weekend. So we're around all the time. We can see our 2 houses, Mr. Stickney's house and mine. Getting back to the pin that's in that corner, you can see the jog in the line that's shown on the survey on lots 102, 103. there is a line, the most southerly line that runs from the lake up, runs from the road up to the back pin that I'm referring to is 224 feet. The Stickney lot only goes 150 feet. And again, as Jason said, don't know who to blame. A lot of folks have been blamed about this, that, and the other. But I could see how a contractor could look at that and say, yeah, that must be the corner lot, without having the sketch. Unfortunately, the contractor put the sketches together. It showed the location of the home, it showed the jogs on the lots. So I don't know how that got mixed up. The pink flagging that was installed was not necessarily installed by the forester. It was installed by myself. I have a bunch of pins on my back line that when you were standing, the folks that were on the sidewalk, had looked down to the south, you would have seen a whole row of pink flagging through the woods. I tied off all the pins that I had on my property because I wanted to measure up and see if that pin was located accurately within a few feet. It had been put there in 1955. I didn't know whether it had been moved or how accurate it was, and it turns out it was accurate for that location. I left the flagging in place because I've got 7 grandchildren that play up there in the woods. Instructions are, if you guys see that flagging, turn around. I don't want you going past that. That's the point of the flagging. It's got nothing to do with the forester. He blazed trees in the woods and he paints them, absolutely. But the cost for refreshing the blazed lines, not the property lines, but the blazed lines, is about $2,000 for that 100-acre parcel. So it's not a survey quality effort by any stretch. There's no deed work that gets done. There's no anything like that. It's just looking for types of trees. The orientation that Mr. Hennessy mentioned, the orientation of the sketches compared to what was built is 90 degrees different than what was submitted. I have absolutely no concerns with the applications when they were submitted. They looked accurate, it was well off the property line, and didn't think anything of it. I was walking down the road one day and I saw that the contractor was up there doing work and there's a huge dead tree in the back. I walked up to him, I said, if that's in your way, go ahead and take it down. I would do that today. It was a good sized tree. Didn't want it coming down on a brand new house, whether it's on my lot or my children's lot or Mr. Stickney's lot. They'd worked around it. I said, take it down. Just trying to be neighborly. It no way implies that I gave him permission to build a house on land that either I own or that my children own. So those are just some of the issues that need clarification. After the survey was done, we did give, Jonathan and I talked, gave him a verbal proposal, followed up in writing. He responded back on August 16th, 2024. Excuse me, we responded and reiterated our initial proposal in September 3rd-ish. And then in October, we received a letter saying that they'd like to undertake non-binding mediation, and we split the costs. Well, my position is we haven't done anything wrong here. Why should we be incurring costs? We'll participate, but we're not going to incur costs, and that's where that discussion ended. And to the best of my knowledge, there haven't been any counteroffers or anything since the fall of 2024.
We don't need to get too far into that.
Yeah, okay. I think this NOV helps the discussion, at least, from facilitating things, and that's really what we want to accomplish. But they've got to be reasonable conversations. We gave 2 or 3 options that Jason's been talking about, and we're happy with any of those. We'd rather have the house pulled ahead, which Jonathan says he has room. We'd sell him a piece of the land, but it's at a price more expensive than moving the house. We'd rather have the house moved ahead. And then if there's some other option, we'll figure that out. But we're wide open for discussions. So anyway.
Thanks, Doug.
Yep.
Can I just ask you one
Yes.
point of clarification?
Yes.
That back pin that we were talking
Yes.
about on the survey as the 1-inch iron pipe
Yep,
1.8 above grade.
correct.
Is it, did I hear you just say it's your understanding that that pin was placed in the 1950s?
1956 probably,
Okay.
when it was surveyed. And I've got a whole row of pins. Those are 50-foot wide lots. Many of the lots had pins on all four corners. Over the years, they got moved, they got pulled out, they fell over, whatever. So,
Okay. I'm trying to match this up to what I see on the survey.
yep. I'm sure, not to drag you into this, Fred, but out behind your property in the back, there are blaze lines in the woods. They might be close to the property line, but they're not intended to be the property line. Fred's got pins back there that mark the property line.
Thank you.
Thank you.
Is there anyone else here in the broadcast studio that would like to speak against this appeal? Is there anyone in Zoom or called in that would like to speak against this appeal? See a hand raised. I don't know who you are, but
That is Brendan.
okay. I think you're on mute, perhaps. I see you talking, but no words coming out. Not hearing anything. If you're talking, we are still not hearing.
Does the person in the studio need to unmute?
You are muted.
Still nothing.
Brennan, you need to unmute yourself.
Our tech guy says on your end, it looks like you're muted.
Yeah, I was trying to call in from my
There we go.
phone.
We can hear now.
This won't sound
Good.
good. Can you hear me okay?
Yeah, if you can just let us know who you are and.
Sure. My name is Brendan Morrill, so I'm one of the co-owners of the abutting property at issue here. So first of all, I just want to say thank you for everyone for the time here. So I know we're going on an hour and a half. My brother Aaron joined late, and he was texting me asking if this was still going. You know, in our minds, I think it is pretty cut and dry, based on, you know, almost what Mr. Stickney's attorney had said in looking at and not disputing the results of that survey, right? So we do feel that the notice of violation was issued correctly, and that, you know, it shouldn't be stayed. It's really the only thing that's forced some action here. As my father alluded to, we've tried to have those discussions with Mr. Stickney through himself and his attorney that haven't really gone anywhere. So, you know, when we look at that survey, and it seems pretty cut and dry, and the notice of violation being issued, you know, we feel like that's the proper action. And it doesn't preclude the other actions that he's referring to. So the civil matter through the court system can continue to take place. You know, happy to entertain that. As our attorney alluded to, there'd probably be a counter claim there. But, you know, I just wanted to voice my opinion that, you know, I'm in opposition of the stay. So that's it. Thanks, everyone.
Okay, thank you for your time tonight. Is there anyone else on Zoom or called in that would like to speak against this appeal? Is there anybody in broadcast studio that would like to speak on this appeal from a neutral perspective? Is there anybody in Zoom that would like to speak on this appeal from a neutral perspective? Okay, I'm going to go ahead and close public comments. Mr. Stickney, if you or your representation have any final comments you'd like to give, you may do so now. What's that? Jason, do you have anything final?
Nope.
Do you have anything for us to procedurally before we kind of close and go into discussion?
No, I don't.
Okay, and I'm going to go ahead and close out comments and move into board discussion. I guess I will ask our attorney one thing. I'm a little, it feels as though the appellant is asking us simply to stay this. I didn't get any real responses to any other action it's seeking out of the board other than to stay. I'm not sure. I mean, we can review the notice of violation, see if Jason's assessment of things is accurate. But outside of a request to overturn the notice violation, I don't know what we can discuss outside of whether we should stay it. Am I understanding this correctly, or procedurally what should we move forward with?
The appellant has the burden to show that it should be overturned. There was the argument in the first submission that the board doesn't have the authority to change the lines, change the boundaries, and there seems to be some agreement between he and the CEO on that. So I didn't hear them address directly the survey, other than to say, the lines in the survey, other than to say they didn't agree with them in a court action. So I guess you've got to determine whether or not they've made their case. If you determine not to stay, you've got to determine whether they made their case to bring forward evidence that to prove that the NOV was wrong.
Okay. Okay. Yeah. So, as I hear it, there's obviously a request to stay, but the stay is dependent upon a third-party action, a civil suit, for which, the notice of violation is a town issue, a town enforcement. Yes, there's a potential solution to this through a civil action or civil, but I mean, this notice of violation, this is the town issuing something to a resident of the town. So I don't know that we have any reason to consider a stay given what was presented to us, and waiting on a civil action. So I feel very strongly that we don't consider staying or tabling this, waiting for the results of that. But I am open to hearing you guys' thoughts on that.
Do you say you feel very strongly or you don't feel very strongly? It's a pretty big difference. I'm just trying to
I
understand.
feel very strongly that we do not consider staying this based on a civil action. The results of a civil proceeding. It's outside of what the town is here trying to enforce a zoning violation. To me, that's what our focus should be. A violation was observed by code enforcement, action was taken, notice of violation issued, and an appeal came objecting to that notice of violation. They request a stay, or they're requesting us to table it, waiting an undetermined amount of time for the results of a civil action, but it doesn't change the fact that, Jason has observed zoning violations, action was taken as per our ordinances, and that's what I think our focus needs to be here tonight, is the notice of violation valid? So I don't see that we can or should entertain the request to stay.
I have a question for council, maybe.
Yep.
I'll ask you, and you can.
No.
Does tabling it have, or what is the implications if let's say it was tabled from a? Does it change the way fines or anything might be calculated? Like, I'm trying to understand what the implications would be one way or the other. Like, does it actually change anything?
It changes. Let me back up for a second. I guess, and first I want to just observe something just practically about a stay. the town isn't a party to this lawsuit, so it's not going to know when it's resolved. And so if, just practically speaking, any stay should be bumping off for a date certain to bring it back up and have the parties come back in 6 months or a year or 2 months and say, is it still going? Because that's your authorities to create an agenda and ask people to come. After this, there's 2 different potential court proceedings after this. The first is, and they're, as lawyers do, they name them in confusing ways. One is called an 80B appeal, which is, once this is final, they have 45 days to go to Superior Court to say, no, the board is wrong, and overturn the NOV again. The second is what's called an 80K, or proceeding, which would be to kind of seek to enforce the NOV in court. And so that's where you get into civil penalties and attorney's fees. It gets procedurally kind of a bit of a mess when you get one or those, and potentially both, involved in a case that's going on that doesn't involve the town but involves the same kind of issue. So what happens? So there's going to be town's attorney's fees, and that's one of the things that you could seek, the town could seek payment for, but that's, so staying it prevents the running of attorney's fees, or significantly decreases them.
Sorry, staying it prevents that, or would
it delays
perpetuate the attorney's fees?
It delays them being incurred, and so once.
Oh, it delays them.
Right, and so whether it's me or the town attorney kind of going to court, there's going to be a decent amount of cost in just responding to that, if they appeal or bringing an affirmative case for civil penalties.
Maybe if I can narrow the scope a little bit of my question. I think I'm being maybe a little too broad. I guess like specifically what I meant is like our ordinances talk about, a certain dollar amount per day that occurs. If the board tables this, that day accrual still continues, or does it no longer continue, or does it have any bearing on how those days are calculated? That's, I think, maybe just to pin it down a little bit more.
Yeah, thanks for the reminder. You were clear the first time, and I forgot it.
No, it's all good.
The background. I don't know.
Okay.
Is the answer. The NOV doesn't speak to it. The ordinances, I don't believe do. I reviewed that today. I don't recall seeing anything that could be kind of read to infer some kind of a tolling situation. Okay. There would be arguments on both sides. I think the town would want to say, they're continuing to run to create some incentive, even though there is a stay. They may say, well, it hasn't yet been decided, so it wasn't. So, but that's going to be an issue for the court. And if the court finds that there are, in fact, once the determination is that this is a violation, it's mandatory that there's a penalty. The discretion then becomes how much. And so it's what you're pointing your finger on will be the fight in the second action about the penalties is how much do they accrue and how fast, and what are some of the factors that should go there.
I guess, David, then, just to play the other side of this, the town's, at least my understanding was to have this resolved and outside of the town's involvement. I think their NOV got that. The appellant is asking for just to delay, which it doesn't seem like, the alleged encroachment was in 2024, right? Like, we're talking, if we were to table it, again, I'm just trying to think through the other side of this and say, let's meet next month. I don't think it materially changes anything. So I'm just putting that out there for what it's worth. I don't know if it's worth anything, but I think that's just my understanding of it. It seems like the town's goal would be met either way, because it's not like unless we vacated the violation, which I'm not even sure there's been an argument that that should be done.
And that's an enforcement issue, which is really outside our
Right.
scope.
Well, no, I mean, we could say there was an error.
Again, but it's a type of enforcement. I mean, vacating a certificate of occupancy.
No, the NOV.
Oh, vacating.
That's literally our mandate, right, is to uphold the NOV or vacate the NOV, or, right, send it back.
Yes.
Right, so I'm, like, I don't think that we're really even, I don't know. I guess I just don't feel as strongly as you do, and I'm not sure, I'm not as sure that it's not cleanest just to honor or table it. I think that the outcomes are very similar, I guess. It may be cleaner.
Mr. Chair.
And I think that is in our purview.
Mr. Chair,
Hey, David,
if I may
this
add,
is,
just
1 second, Tom.
a clarifying point.
okay.
The practical effect of a stay would likely be measured in years. One of the attorneys kind of spoke to a little bit of the court process. Once they're served and they have 90 days after it's filed for it to be served, that starts, then the court in the next month or so will issue what's called a scheduling order. That will give about a year for discovery to happen, for them to kind of go back and forth and find the facts, that some of which have been adduced here, but there's some disputes. And so there would be a year for that, and then there will be motions back and forth, and there may be, so it's going to be, this won't go to trial for
Right, but we could
2 years out.
Sorry, I'll interrupt you. Just to clarify what I meant is we could untable it next month.
Absolutely.
Right, but let's just say, okay, you got to tape. You filed the appeal. You asked for a stay. We did that in the form of tabling it. You got 30 days. We'll see you in 30 days. Hope you make a lot of progress. Like, I think that meets everybody's stated goals. If the town's goal is to make progress, the Morals' goal is to make progress. We're not impeding that progress by tabling it.
Yeah, but I think the point I'm also hearing tonight is we've had anybody, the Morals and Mr. Morrill and his children, they all have advocated against this appeal. They're not advocating for the appeal and having them stay. They all said no. So I think you're missing the fact that the third party in the civil suit is telling you no, stick to the appeal. Yes, you have the other party saying we want to stay.
No, I guess what I'm saying is whether or not we, and our counsel just sort of backed this up, if I understand it correctly, is like, if we were to table this, wait 30 days, I don't think it has any bearing on the civil matter. Like, the Morals haven't even been served yet. They probably, like that's going to run its own course. I'm just merely pointing out.
What's the purpose of us delaying 30 days to make a decision that we can?
Well, it was the stated goal of the town to make progress. It seems like that may be happening, and the appellant has asked for it. I think those are the strongest points. I'm just trying to point out the.
But a notice of violation has been served.
Yep.
Meaning the town has identified an issue. Jason's followed what's required of him through the ordinances. We're simply here to uphold the ordinances.
Right, but we do control the agenda of that. Like, it's in our purview to table something if we feel like
Hey, David, can I insert myself here somewhere?
Yeah, I'm sorry, Tom. Yes, please go ahead.
That's okay. All right, so we've heard a number of people that don't want to stay. We've heard Greg's argument doesn't, prevent opening it back up in 30 days. But that's not progress. I think we need to put it to a vote, stay or not stay, amongst the board now, and end the discussion unless somebody else has some other opinion.
Yeah, what we're doing is discussing that, though. We don't need to prematurely end the discussion. This is actually part of the deliberation, though, Tom. Like, I appreciate your.
I want to hear from Fred and Pete.
Sure.
Greg, we've heard from you.
Okay. guess I'm not allowed to talk anymore.
I guess.
Thanks, Tom. I'm not sure. Like, I might have to. I think I'm going to file an appeal.
You might need to stay.
All right.
Just move ahead, and you can have it
With all due
turned
respect,
back.
no, honestly, Tom, with all due respect, this is part of the process, okay? Like, I appreciate you may not agree with me, but with respect, I think I get a chance to at least make my points, just like David did. So I appreciate your move for action, but the whole point is everybody should talk. So.
And I'd like to hear from the other two opinions on the board.
And as we always do, Tom, we all get our chance to have opportunity to
Duly
speak.
noted, Tom.
So,
Brad, you were trying to speak.
Well, yeah. I think, Greg, you took over, you took over my heart that I have, where your compassion is there for what's going on. And I don't exactly how I want to say this or whatnot, but I understand the town has tried to prolong this out to make a decision happen down the road. I'm not so sure, sitting here, that is something that's going to happen in 30 days or 60 days. And that's not really what the board is here for, other than if everybody said here, yeah, I think we can get this fixed in 30 or 60 days, then I think that that would open my mind up to say, okay, well, this can get fixed. Maybe we can avoid this novena that we have. But I think in the situation we're at right now, I don't feel that that's what's out there to happen, which my heart is killing me to have to do that. So the only thing that we have for options is, did the town file a NOVA of a violation under the correct ordinances? And I think what we've seen for evidence in front of us is that I think the town, I think Jason did the right thing, and I think he did it in the right thing, and trying to wait for it. And I think if we all had something in front of us that said, yeah, in 6 months or in 60 days, this could probably be resolved. And I think, Greg, your idea is great, but I don't think that that's going to come back to us. I think we just have to make a decision, because we haven't heard any evidence, for what was given to us up front. And up front is, did the town serve a violation under its ordinances? And it's up to us to make a decision, did we do that right or did we not? And if we did not, then we vacate it. If we did, he did, then I think we have to, uphold the town. I mean, my heart is right with you, but I mean, we don't have that in front of us. Pete?
Yeah, so first of all, I think you're both very convincing. But I think in this case, having heard all the arguments or whatnot, I don't think that we'll really be doing the purpose of this board or the town by staying. I think that we should be trying to help this process to proceed forward.
So we will take this to a vote. Greg, did you want to have anyone?
Do you want a motion from me, or what are you asking?
No, I just don't know if there's anything more you wanted to.
I don't think you might want to make sure Tom got his word.
Tom, do you feel you had enough? You had your chance to say?
I'm ready for a vote.
So, I guess the correct motion is to deny the stay. Would that be?
Well,
Yeah, I think there could just be maybe just a straw vote. Probably the easiest thing, because that's not a formal, that's a request, but not a formal action for a formal item before the board, so.
Gotcha.
David, do we have two actions? One on the stay and one on the actual NOV?
That's a good question. What is specifically are we going to
So the motion will need to be on whether to, if you do choose not to stay, the motion will be on whether or not to uphold the NOV or reject it.
Okay.
The request for a stay isn't formally before the board, and so that could just be done in some kind of a straw poll. You could also do a formal motion if that feels better.
Well, we could perhaps do it in the form of a motion to table it, and then that could fail, and then that would be documented.
Yes,
Because I think that my point I was trying to make is that the stay is sort of I think maybe confusing the decision we have. Like to table it just pushes it down a month. We'd have to untable it. But anyway, I think I've said my piece. I just want to.
Procedurally, if this goes to the next step, is it better for us to take a vote or to do the straw vote?
Well, a motion to table would take precedence, and so that would be a formal motion. So,
yeah, I'll make a motion to table it. It seems, for the record.
Do we have a second? Okay, with the lack of a second, it fails to move forward. So we will then move forward with regards to considering the NOV as it stands. Where did my NOV go? Obviously, I had a chance to read over NOV. What is really the best way to go through this? Go through the individual points of the NOV to ensure that it matches, or do we?
You could do that, or you could kind of just go around like you did in the earlier piece about sharing what you think, and then I could kind of ask some questions to the NOV and some other questions. Either one.
Sounds good. I will go ahead and start. Jason does make reference to not meeting setbacks, and he indicates that there is encroachments. The survey that we have shows both of those things. The violation is specific to ordinance chapter 350 for shoreline zoning, article 6, land use 350-6-2, minimum lot standards and setbacks, front 30, side 30, rear 30. This will have to be towards the rear 30. Survey clearly shows that the house is in violation of the setbacks. Jason is not mentioning encroachment at this point. He's just simply stating violation of that specific ordinance. In order to correct the violations, we have one, removal of the portion of the structure. That does match up with Jason's authority under 350-7-8B1. There is number 2, legal resolution of the encroachment through a recorded lot line adjustment approved by the authority having jurisdiction. I believe that is not something that the town can enforce. If we do uphold this, I may say that it's upholded, noting that this is not a town enforceable action, just a recommended action for resolution. And the third aspect is submission of all required applications, plans, surveys, permits necessary to resolve the violation. Per Jason, that would be something he would have to do, especially if there's a movement or relocation of the structure. And then there's mentioning of a follow-up inspection, which obviously that would be at a different time. I don't see anything wrong with follow-up on an NOV, and then failure to comply with listing out of the statutes and ordinances related to fines, and giving it opportunity and how to appeal the decision. So that would be my thing. I believe this NOV is appropriately written outside of number 2, which I could see, and it has been noted that this may come across as a town requirement, which the town cannot require. So it may just need something added or noted that that's really a town suggestion for resolution.
I'm wondering, Dave, if it's covered under where it says recording the line adjustments approved by the authority having jurisdiction, which that's not us. I think Jason may be responding to whoever has that jurisdiction, whether it's the court or whoever. Am I taking it that way?
Yeah, I think in this case, it's referring back to me as the code officer approving that the lot line, for example, if one of the lots didn't have enough acreage, we wouldn't be able to approve a lot line adjustment if it was making that lot more non-conforming.
Probably need that.
Yeah, I mean, I think the corrective measures aren't something we're making a determination on right now, right? We're just, what if this is the violation correct or not? Is the appellant in violation of this ordinance? Right?
Well, I bring up number
So I'm not
2
sure.
because that was part of the initial submission by the appellant, saying that the town cannot require the land lot. And I could see through reading this that it can come across as number 2 being something the town can require, but I don't believe the town can require it. The town can only suggest it. I don't think there's anything wrong with that suggestion of action, because it's a nice alternative to having to remove everything. But my only point is, yeah, keep 2, but just indicate that it's can't be required by the town. Like, we can't require Mr. Stickney to move forward with that, nor can we require his neighbors to move forward with that. That would be my only suggestion for mod, but I don't see anything wrong with the NOV in terms of the violation and the required enforcement action outside of that number 2 needing a slight tweak.
Tom, you got anything you want to add?
You're on mute if you do, Tom.
I'm sorry, did I miss the question? Sorry.
We're just wondering, so I've had Greg's had a chance to have some, just wondering, do you have any comments with regards to the NOV? It's whether you find it to be valid, parts of it invalid?
I believe that NOV is valid and it's backed up by the survey.
Fred?
I have nothing more.
Okay. Okay. So we've had our out loud discussions.
Okay. Can I ask you a few questions?
Yeah, please. Yep.
So I've all right, so I've got a proposed language here and and some of the basic things, and then, does the NOV does meet, the ordinance does not, things like that. So it's not determining where you'll go, but some questions. And I'm kind of looking to skip down them so that when I come back next time with some proposed language, it's something that reflects generally where the board is. So Mr. Stickney owns the premises, the district in which it's in. I'm summarizing some of the testimony that I've heard. The names of the people who own title to the property that abuts the property, and it was suggested it was along the rear lot line. Is that agreed?
Correct, yeah.
Initially code enforcement officer Hanson that determined that construction had begun on the premises without a permit?
Correct.
Then it recites the permit number, and then the note at the face of at the bottom of the permit that talks about that the CEO discussed, that the applicant has the burden of ensuring has legal rights to the property, and so on and so forth. And it's recites the stamped boundary survey. One of the questions that I have in listening to the testimony is, do you have a clear understanding of when the town got the survey?
Yep.
I have it noted as July 9, 2024,
Is that,
per testimony of Jason. Mr. Stickney didn't have a definitive date as to when.
It was commissioned June 15th, so shortly there. He said it would, per Jonathan's testimony, it would be, he would have given it time quickly, so.
right. So do you have, is there a consensus that the June 9th, 2024 is, I mean, do you find that that's the date that it happened, or what do you find about when the town got the survey?
I think you said it was several days after he received it.
Mr. Stickney?
Yep.
Yeah.
Yeah.
But that was in the middle of June. Yeah.
Yeah, it's commissioned in the middle of June.
Commission in the.
Yeah, and
And
then Jason said he got it, and then the.
Well, I guess, I don't know. I can't say definitively, no. I believe I heard Mr. Stickney to say July, and then I believe him to heard him say within a few days of receiving it. Submission date on the survey is June 13th, 2024, but that doesn't necessarily mean that's the date on which he received it. I believe submission is when it's sent, but I don't know if that's when it's received. All they have for definitive date is July 9, 2024, which we heard from code enforcement.
Discussing that the certificate of occupancy was issued on June 28th of 2024. CEO Williamson's letter to the owner talking about the potential violation. The June 15th, 2026 notice of violation that citing the violation that the structure does not meet the setback in the shoreline zone in violation of.
January.
January, I was going to say it.
Oh, then it was.
You said June out loud.
Well, it's January in the thing. Thank you for that. Yeah, it was on January 15th, 2026.
Yep.
And then citing the section of the ordinance that the NOV cites, cites the date of the appeal, February 12th, that the owner appealed. Town staff provided notice to the abutters, the site walk. The discussion, it's, so one question is whether or not it's a pertinent fact that the owner asserted that it filed a lawsuit on March 27th, and then to kind of support the request for a stay. So I had, is that something that should be in there from your perspectives?
I mean, I feel like we're just determining whether the violation is correct or not. So I'm not sure what, I get maybe not sure why the civil has any bearing on that, right? Like it's do we want to approve or deny the appeal based off from the facts that were presented? So yeah, help me think through like.
It's highlighted for me to raise the question.
Gotcha, okay.
So I know that the civil suit was brought to the board's attention by email on this past Monday. It's mentioned tonight as part of the presentation. I did read through the civil suit. There's facts in there that, or information outlined that was reiterated through Mr. Stickney and his representation. So I guess technically it's a part of the official record. So did it have bearing on the deliberations? For me, no, but in terms of the actual being a civil suit.
Yeah. So if there was a appeal to this, it would be part of the record because it was given to the board. We had two members saying that that's not what they're basing their findings on, and so you don't need to include it if it's not what you're basing the finding on.
Okay.
Is that consensus? Okay. So then there's a finding that the shoreline zoning ordinance applies to the appeal. And I'm kind of pausing, it doesn't seem like there's a disagreement. That the appeal of the notice of violation was timely filed, and that the board has jurisdiction.
Yes.
So this is the first does not. does the board find that the structure of the premises does encroach on the minimum 30-foot rear building setback or does not encroach?
Well, the encroachment would be on the neighboring property, correct? It sits within the per the survey, it sits within the setbacks, which would be the violation.
Correct.
The encroachment would be on the neighbor's property, correct? At least that's how my understanding of the words, encroachment versus.
It doesn't meet the minimum 30-foot setback, or it does meet the minimum.
It's less than 0. According to the survey, it's less than 0 feet.
Yeah.
Okay.
So
So it does not meet the 30-foot minimum setback.
Correct.
Is that a consensus? Okay.
Is the board does not meet the setbacks and it's an encroachment? Is that what we're trying to say?
You could say that. The ordinance requirement is that there be a 30-foot setback. There could be, you could, does the board want to add an additional observation that the survey shows that it encroaches in the neighboring property?
I would say yes, only because the notice of violation makes reference to an encroachment as well.
Is
But
that
it's not an enforcement action.
Yeah. So then there's the question about the notice, the certificate of occupancy. And the certificate of occupancy references back to the permit. And so do you have anything to say about the certificate of occupancy and its validity based on that or the permit?
And given what was outlined through Jason, I don't see that. I believe the certificate of occupancy to have been issued based on the information available, issued correctly based on the information available at the time. Is that what you're looking for?
The information available given during the permit application?
I think I'm missing I guess I'm missing the best question.
There was some discussion about whether, so there's an assertion by the applicant, or by the appellant rather, that the certificate of the town can't enforce because it issued the certificate of occupancy. And so what do you find on that point?
I was not, no statute or no state statute or ordinance was provided indicating that a zoning violation is not enforceable regardless of a certificate of occupancy. So I don't see that having a certificate of occupancy, avoids zoning violations to be enforced.
Okay. Is there, to kind of go back a second, you'd said earlier that the permit wasn't void on its face when it was issued because it was issued based upon the I'm added void on its face, but was based upon the information that the CEO had at the time. Is that
plot?
The handwritten plot? That's a consensus and that's important to include? Is that important to include?
I'm not sure that it's important to conclude, nor is it really, I'm not sure that it's a consensus. I mean, I'm just, I think what's important to conclude, and I'll let everybody else comment, but is the survey that was provided and the NOV stating that the ordinance was, that the appellant is in violation of. That's all I'm really basing this on. I'm not even really, the CO is, I'm not sure how relevant it is. There was, it's the burden is on the appellant. And one way to phrase it is the burden is on the appellant. I don't think that burden has been met to approve the appeal. And the reason I don't think so.
What facts do you base on that? That's not
this, which is the appellant's own survey.
And so what does that So go a little further with that. So there's a survey.
Yeah, the ordinance specifies a 30-foot setback on the rear boundary, and there's less than 30 feet.
But the appellant's argument is it doesn't matter because you've issued a CO. Even if it was issued wrong, it doesn't matter what you find later. So what facts do you find?
I think the CO even says that it's the responsibility of the property owner to ensure that it's correct.
And that's what I'm asking.
I see. Okay.
And so is that important that it's the permit that actually has that language? Is it important that the permit has that, or is that not something that you're finding is important as you conclude?
I think what's important is there was not a compelling argument made that would make me want to overturn the so I don't even, yeah, that's where I am.
I mean, for me, it's this section of our ordinance, 357-8 enforcement. Any violation of these ordinance provisions shall be deemed, there's a violation, code enforcement identified the violation and has taken action on it, given what's outlined in our ordinances.
Okay. Anything else from other board members on that line of questions? Okay. Are you comfortable with what was said?
Yes.
Okay. All right, and so you use the language, you didn't find a compelling argument to overturn the NOV. Specifically, one of the substantive argument that they make is that the CO precludes the town from doing that. Would you find that the certificate of occupancy does not preclude the code enforcement officer from enforcing the shoreline zoning ordinance?
Make sure I get the negatives right here.
I mean, I heard that as an argument.
Right.
I saw nothing was presented to us essentially to back it up.
Yeah. I think that's what I'm trying to say is it was said, it was not substantiated with oftentimes when there's an appeal and there's some sort of statement or claim that, there's this document is the proof, there's some sort of case or there's a reference to something.
There was cases.
Okay.
There was citations to ordinance, not cases, excuse me.
That a CO supersedes, okay, that's material then. If there's an ordinance that says that the CO obviates or you can no longer.
So this was the reference to the land use ordinance.
305.
There was some back and forth on that in the testimony.
Right, but I didn't think, maybe we should review that again. I actually have it open right here. You're talking 300-5.5, right?
That's what was cited.
Yeah.
You can read it out loud if you want, Greg.
In each instance, so I'm reading, for the record, I'm reading 305-5.5 from the land use ordinances. All right, this is, in each instance, 1, in which different use of a building, structure, or land is proposed, or 2, following erection, alteration, repair, enlargement, or relocation of a building or structure, a certificate of occupancy shall be required prior to occupancy and use pursuant to the requirements in the main uniform building and energy code. Neither the owner nor the person to whom the building permit has been issued shall permit any building, structure, or land for which a certificate of occupancy is hereby required to be used or occupied until the building inspector has issued a certificate of occupancy. Therefore, a certificate of occupancy shall not be issued until the building inspector determines that the building, structure, or land use has been completed in accordance with this chapter and any conditions imposed under this chapter. The building inspector may issue a temporary use permit valid for periods not exceeding 6 months during erection, alteration, repair, or enlargement of a building or structure. A fee for plan examination, a fee for each plan examination, certificate of occupancy, and inspection shall be paid in accordance with the schedule of fees as approved by the Board of Selectmen. That's the end. So that to me, and I would defer to fellow board members here. I'm not sure what conclusions you guys come from that, but there's emphasis on the what's the specific wording, David?
I got it for you, Rick.
Yeah.
So the building inspector determines that the building structure and land use has been completed in accordance with this chapter and any conditions imposed under this chapter. So basically, it's if this can, if a issuance of a certificate of occupancy blanket says that it's been completed in accordance with this chapter and any conditions imposed under this chapter. Basically, the chapter is a whole ordinance. So meaning if there's a zoning violation, the certificate of occupancy is issued, a subsequent zoning violation is found, doesn't matter because the CO was issued stating that there were none. So essentially saying that somehow it has overriding authority over subsequent discovery of setbacks, or not even setbacks, just any sort of zoning violation.
I mean, I don't.
I don't see how you can reconcile that with what we just went through with shoreline zoning 357-8. If there's a violation of the ordinance provisions are found, it's the duty of code enforcement to enforce it. So given the timeline, the CO was issued with the clear picture that there were no setback violations or any other violation. CO did determine later that there was a violation and has subsequently taken action on it as is required through the ordinances. I don't see how it makes no sense to have, if a violation wasn't known and a CO issued, that can blanket cover the fact that there's a violation.
Right.
A violation is a violation. It's got to be addressed.
Right, I would agree with that.
Per the ordinances.
Mhm.
So I don't know if that gives you.
Okay.
Would you agree with all that, Tom?
Sorry.
I would agree that the NOV can be written anytime after the certificate of occupancy, and it has no overriding effect. We deal with these NOVs all the time, and there's no question, except this time it's a brand new construction. So the NOVs can be written at any time, and that you could have something that's 100 years old and it still could come up with a violation.
Okay.
One thing I'd point out is this was the information provided for the CO, correct?
Yep.
Right. So when you get a CO issued with this, and then a couple of years later you provide this, that doesn't just from a logic perspective, this isn't a get out of jail free card, so to speak, right? That's my perspective, is it's wrong, or could be wrong. I think compared to this, it's wrong. And so, I mean, what would be the case in which the CO would the town then have to go survey itself independently to arbitrate all possible drawings before a building permit is issued?
So if I can, I'm going to try to kind of restate that in the form of a fact. And,
okay.
And you're pointing to documents that won't be seen in the record. So the permit application relied upon the handwritten plot plan that showed, and the CEO at that time apparently determined that it met setback requirements. When the applicant later conducted a survey, it showed more information and showed that the handwritten plot plan was wrong, and that's when the violation was shown.
Yeah, right. That's my understanding.
Is that?
That's my understanding. So I'm just trying to
No,
really
that's
pin it
not
down.
my understanding.
Okay.
The handwritten one was not wrong. It was that they didn't follow the handwritten one.
That would be more accurate. I would agree with you, Tom. I guess it's the.
Well, one's a building. Okay. Well.
So I see what you're saying. Technically, in the long run, it ended up being wrong, but when it was initially submitted, it was correct.
Okay, but I think it matters.
I get what you're saying.
But it might matter, and I just want to I think Tom raises a good point, because the CO is issued on the observable post once the structure was built. So if the structure was built and it didn't match what the drawing was, that would have been something that I believe should have been incorporated into the prior. That's knowledge they had before the CO was issued. I think that's the only point I want to. I'm not sure if it means anything. I just think Tom raises an interesting nuance there. Like, this was provided for the building permit. The certificate of occupancy should have been issued on an as-built basis. Is that how that? Am I getting the sequence of these different steps right?
I mean, the certificate of occupancy is obviously issued after permits then, but, we don't do setback inspections at any point.
But if the structure was built, Tom's stating that it's more accurate to say that the structure was built and it deviated from the permit. And that...
So is this right? So the application was based on the handwritten plot plan. The CEO apparently determined at the time that the ordinance requirements were met based upon the handwritten lot plan. When the boundary survey was conducted, it showed that in fact the setback requirements of the ordinance were violated.
Yeah. But I think the appellant's point is that there's an implied agreement from the CO being issued that the building structure land use was completed in accordance to the ordinances.
But that's their argument. But the question is, what facts are you relying upon to not agree with that? It sounds like there's consensus on that. On those facts. The application was on the handwritten plan that turned out not to have been followed. Okay. All right. So, and I guess the final thing is the conclusion. I mean, there's some other paragraphs that you can review that kind of go to the citations to the ordinance that talk about the power to hear appeals and the burden of proof and so on and so forth. But of the violations that have been cited in the notice of violation regarding the premises, the board concludes that the premises is in violation of the minimum building setback requirement or is not in violation of the minimum building setback requirement.
It is in violation.
Yeah.
All right. So I have enough to draft a proposed order for you, if you find in that way.
Okay. Our typical procedure when voting on something is we will do an official vote tonight to make a determination of whether we grant or deny the appeal.
Mm-hmm.
That will be our official decision. Sandy will send the appellant an email specifically as the official notification on our end of the decision of the appeal. And then we will meet at our next monthly meeting, which is within 35 days, it's each month, end of Tuesday each month, for which we will then review and vote to adopt the findings of facts, which are then subsequently delivered to interested parties.
Yep, that is a very good process.
Okay.
Been honed over the years of
Yeah. Yeah. So do I have a motion to deny this appeal?
I'll make a motion to deny the appeal.
Do I have a second?
I'll second it.
Okay, do we have any further discussion on this before we vote? Okay, roll call vote again. All those in favor of denying the appeal? David Murch, yes?
Greg Dean, yes.
Pete Lockwood, yes?
Fred Miller, yes.
Tom Hennessy, yes.
So that would be unanimous. So, Mr. Stickney, as I've said here, Sandy will reach out to either you or your attorney with the official decision, and we will meet
David, I'll
next month.
prepare that tomorrow and forward it to both of them.
Okay, thank you. And then we
You're
will
welcome.
meet at our next regularly scheduled meeting, which is the last Tuesday of each month, to then go
That's
over
April
the findings of
28th.
facts. What's that, Sandy?
That's April 28th, the next meeting.
Okay, so April 28th, we will meet here to discuss the findings of facts that the attorney will come up with. We will review, discuss, make corrections as needed, and then make a final vote to accept those findings of facts, which will then be provided. So, okay. Next item on the agenda is old business, of which we have none, which means the next item on the agenda is staff communications.
Yeah, I think the big thing right now, LD 1829, you guys all have to get training on that. We've missed the deadline already, but, well, there's already a bill to amend 1829 called 2173. I've reached out to the new main office of community affairs, MOCA, try and get some guidance on how we can get everybody trained. Hoping to get something in town where we can get our two boards together and maybe our town attorney could do a training. I haven't heard back from them yet. It's very specific. I've kind of said, what about this training? Nope, not quite. That's just general, land use. So it has to be specific to 1829, because that's going to bring up, probably going to have to change a dozen ordinances or so, some definitions, and it's pretty encompassing, even subdivision.
Now, did we miss that because the board's incompetency or the town's incompetency?
I mean, you can blame me for that. That's probably my job to.
That's not I'm just trying to say something I need to fix.
Yeah.
Like, I'm happy.
I mean, you guys could find.
Maybe it's both.
It's so hard to find training. There's so few of them. They're not actively, punishing towns for not getting the training, mostly because they haven't offered us any training to get people trained. There's probably been maybe 2 in the last 6 months that I know of, and they were kind of last minute, and I'm not even sure if they would have satisfied whatever requirement was that they made in it, because I thought some things were going to definitely satisfy it, and apparently it didn't, so they're trying to get more trainings. We even talked about maybe trying to get one in Raymond, like more, not just the town, but other people could come too, but haven't heard back.
So this training, is it on the board to individually try and?
That's what I've reached out to him about, and there's not getting good guidance. It was kind of, it's a new thing. I haven't heard back from him in a while. But if any trainings do come up, I'll reach out, and if any trainings do come up, and and I'll see how, because sometimes they're not cheap. So I don't know if we get that out of my training budget or what budget that would come out of.
So this is a requirement for anyone sitting on this board?
Both boards, yeah, planning board, and it said boards. I don't know if the select board would be, but I know planning and ZBA are the two that definitely need to get the training.
And what are the ramifications if we don't take it? Yeah.
They don't have a training police. Down the road, I suppose they could withhold some type of funding if we got some type of funding, because they do reimburse, and there are some grants for like ordinance writing. But
I'm interested in this reimbursements they do. Who is that?
well, like we had to just provide housing data to the state. They're doing a new thing, and so they reimburse you at like $32 an hour.
Yeah.
So,
Yeah.
it's not but there is a grant to write the ordinances. So we're gonna try for that.
Does it block us from being able to meet? Like we have.
No, and like I said, after hearing, because I was at a meeting where they brought up 2173, which is then going to change 1829. The discussion in the room kind of became, well, does it make sense then to wait on this training until 2173 comes through, because you don't want to all of a sudden get into a mindset of, okay, these are the things that are going to change, and then it's like, oh, well, these two things are not going to change, and this one's going to change in a different fashion.
Okay.
Yeah.
Times.
It is. It's interesting, and I went to 2 different trainings, and after the first one, I thought I had my head wrapped around it. Then I went to the second one, and I'm like, it's almost like a different statute.
Okay.
But that's about it, I think, for there.
Well, keep an eye out. I'll keep an eye out for that.
Yeah.
Sounds like if there's no training, it's hard to get training. So
yeah,
I'm not sure what you're supposed to do.
I'm sure I know all the other towns are in our same position.
So I'm definitely in a position of having no idea what to look for or when. So I guess I'm going to rely on you to communicate with Sandy, then she can communicate to us what we have for opportunity.
Yeah.
I know we get MMA emails and stuff, but I rarely pay attention.
I mean, one of them I had to go to an AvCog conference, so I had to go, out of county to get some training on it.
Do they do them online? I mean, or even if it's not on your own, but can it be like a Zoom scenario where we don't have?
They may have some. Hopefully, they do, to make it a little bit more accessible, because some of these rooms, it's capped at 60 or 100 people, and there's so many people at the same time trying to go to these things too. Availability sometimes is difficult.
Okay. All right. Sandy, do you have anything for us?
I do not, because I was waiting to see what happened tonight, whether we had a meeting for April or not, which now we do.
Okay. All right. You guys all good?
All done.
Good.
Motion to adjourn.
Do we have a second?
Second.
Any discussion? All those in favor? David Murch, yes.
Greg Dean, yes.
Pete Lockwood, yes.
Fred Miller, yes.
Tom Hennessy, yes.
All right. Good night, all. Thanks, all.